All right, so wonderful. Thank you very much. So I'm very happy to be here, and particularly, so I appreciate your endurance, particularly those who are not on the social sciences, to sit through this legal part. So what I'm going to do a bit is I'm going to introduce the projects that we're developing with the Max Planck Institute on Comparative Public Law and International Law at Heidelberg. And so the objective is more than telling you about the specific results of the research, is rather to tell you some of the issues that we're trying to tackle and some of the overall projects that we're developing. So that's more or less the idea. And the overall label under which we have gathered all these different projects is the notion of transformative constitutionalism in Latin America. And I'll tell you a bit what it means to be transformative and constitutionalism and, well, about Latin America overall. So that's more or less what I'm going to do. So what's the idea? What is it that I'm going to do? I'm going to tell you a bit about the context. So those of you who are Latin Americans here, of course, are going to know a bit what I'm going to be talking about, and you're going to see some familiar faces in my PowerPoint presentation. And then we're going to see a bit about the core issues on transformative constitutionalism in Latin America, and then some of the challenges. And basically, or obviously, our projects relate to the challenges, so to the stuff that we think is not working quite well. And so, basically, what is the angle and why Latin America? So the angle here is that the basic premise behind our projects is that there is something common going on about public law in Latin America as a whole. So in Argentina, as we just heard, but also in Colombia, Ecuador, Peru, Bolivia, so on and so forth, that something common is happening. And that something common can be understood in terms of public law. And that therefore, we can, by talking to our colleagues in Germany and in other places in Europe, learn about experiences, concepts, different ways of understanding public law in Germany and in Europe, and develop that conversation about the challenges that we have of public law, democracy, constitutionalism in Latin America, engage in a dialogue with our colleagues in Germany and in Europe, and then move forward not only the state of knowledge, but also how actual courts, actual lawyers, actual activists defend human rights and protect democracy in Latin America. So that's more or less the idea. So in that sense, our projects are a bit different from some of yours, because it's not only about developing new knowledge, but it's also about how that new knowledge is deployed in society in order to change lives. So that is more or less the idea. That is why we're talking on the one hand about scholarship, but also on the other hand about courts, about activists, about how academia interacts with civil society in order to protect human rights. So that's more or less the idea. And why is that angle so important for us? Well, because of the context. And what context we're talking about here? So the context in Latin America. The first point, as you all know, is inequality. So Latin America is the most unequal region in the world, which is amazing if you consider how unequal other regions in the world are. So this is, of course, the inequality index, and the darker the green, the more inequality we find. So, and just take a look at this. So take a look at Colombia or Brazil. So it's one of the most unequal places in the world. This is, for instance, income inequality in Brazil. So the top, as you can see, so this is the fiscal income of the top 1%. And below is the pre-tax national income of the top 1%. So take a look at this in Brazil, for instance, in certain points in 2014. The top 1% had more than 27.5% of the income. So what democracy is possible in a context of such inequality? That's one of the key questions. So, and it's not only a problem about redistribution of income, it's also about human rights and about democracy. So that is the first element of the context. The second is, of course, hyperpresidentialism. So presidents in Latin America have a lot of power. We all know that. And this is, of course, Fernando Botero's painting, The President. And we all know how, the notion of the caudillo, the actual fact that we use the word caudillo in Spanish to signify the notion that a president has too much power. That and desaparecidos, as we heard before, are perhaps Latin America's two key contributions to global language. caudillo and desaparecido. So you start realizing what kind of things we're talking about here. So how come or how can we develop constitutional systems that control or at least balance this extreme power of presidents in the region? The third notion is what we call in the projects that we develop with the Max Planck Institute, selective institutionality. So what does that mean? So it has become common sense to say that the state is failed in Latin America, that that institutions don't work. But that is actually not true. As we all know, institutions are very efficient for some and very inefficient for others. So police are very effective in repressing some and very ineffective in protecting others. And we know that. So the notion is, how do we develop a vocabulary from the discipline of public law that accounts for this selective institutionality? So how do we understand this building of institutions in that sense? And the third notion is what we also call in the project Democracies asesinas, killer democracies. So what's the idea there? We all know, and we heard from the presentation, from the brilliant presentation before by Agustin, that a key moment of public law and democracy in the region was dictatorships. And then supposedly we're over dictatorships in which states are supposed to be basically not killing their own populations. But in fact, what we know, and supposedly we're living under democracies. But in fact, what we know is that Latin America is the most violent region in the world. This is, for instance, the 50 more violent cities in the world. And if you look at this, most of them, actually all of them, except 4, are in Latin America. In fact, the 10th most violent cities in the world are in Latin America. So that means that even though we're living in a system that is supposedly democratic and that is not a killing system anymore, in fact, if you live in a city in Latin America, you're living basically in a killing field. So how do we account for this very sophisticated system of public law and democracy when you have inequality, hyper-presidentialism, selective institutionality, and basically a very high level of violence? That's the context. And that's something that is not... So this mix is something that you only find in Latin America. However, you find each of these different elements in different places in the world. So part of our project is to account for this dimension in regional terms, first. Second, we work from the discipline of public law. We are engaged in interdisciplinary research. We want to develop interdisciplinary scholarship, but we think that law as a discipline has a distinct language to contribute to understand these issues. Not only to think of them, but also to think of an answer to them. And in that sense, we think that as lawyers, distinctively as lawyers, we have something to contribute to scholarship in terms of our colleagues in the Max Planck. So we're always a bit ashamed when we present our projects because, I mean, look at the names of these marvelous issues. So nanotechnology, this, and then, so it's amazing. And we are always thinking, so how is it that we bring a different vocabulary way as public lawyers? How is it that we bring it? And part of our intervention is to say, yes, we have a distinct vocabulary and we have something to contribute in those terms. Anyway, so what is it? So what are the core issues and why do we speak of transformative constitutionalism in Latin America? So 4 things. So 4 common things, if you want. So the first thing is that, believe it or not, in Latin America, in all the region, actually, of course, with different levels of penetration in depth, but most constitutions have a very generous Bill of Rights. Of course, all of you are going to say, yeah, but that's not complied with, and we know that. But at least we have them. And that's something that is not a small victory. So the second dimension is the role of judges. And that's something that's very different in terms of Latin America. So what is the case here? So the key dimension here is that a lot of social transformations in Latin America have occurred because judges have taken certain decisions. I'm going to give you later on a couple of examples, but think of the most important social developments in Colombia in the last 5 years, if you want. Take, for instance, same-sex rights. Take, for instance, abortion, the very peace process. In each and every single issue, you had the Constitutional Court saying something about that. Is that enough? Not. Certainly no. Is that necessary? Evidently, yes. So it's not sufficient, but it is necessary. And that's something that is different, because a lot of these debates elsewhere, in other places, normally occur either in Parliament, so not through judges, or through executive action, because a leader somewhere makes a certain decision. In Latin America, judges do that. And judges do that because of this very generous Bill of Rights. Bill of Rights means the number of rights that are included in a constitution, the number of rights. So they have these tools. And the third thing that is interesting here is the openness to international law. And that is why we can engage in this very fruitful conversation with our German partners. Because all of our constitutions have these very open spaces in which international law is applied directly in Colombia or in general Latin America. So international law is the law, the rules that regulate normally the interaction between states. And those are the treaties. And normally what you have is constitutions in Latin America. So for instance, the Constitution of Colombia say, this constitution, they say, well, what international human rights law says should have an effect under Colombian law or before Colombian courts. And that is the reason why you hear all the time in Colombia, for instance, that certain decision doesn't comply with the decisions of the, for instance, the Inter-American Court of Human Rights. Because what they say is important not only at the international level, but also at the domestic level. And it's the same thing in Peru, in Mexico, in Argentina, Chile not so much. Chile are kind of the outliers in that dimension. Yeah, so we work a lot with the Chileans in that sense to debate with them. But yeah, Chile is certainly an outlier because their constitution, they live still under the constitution adopted under the Pinochet regime with some amendments, but still they have that constitution. So Brazil is the same thing. So basically the point here is, the other difference here is that then because these constitutions, these legal systems are open to international law, then the role of a court, a regional court, that is called the Inter-American Court of Human Rights, that is there, that photo is a bit not up to date, but still. The court, what they decide is crucially important to what happens at the domestic level. Domestic level meaning what national judges decide. That is why a lot of our work in our projects with the Max Planck Institute in Heidelberg is precisely to interact with the Inter-American Court of Human Rights. A lot of the funding that is executed in that sense is to bring the judges to Heidelberg. And they go almost, some judges go almost every summer to Heidelberg. And they interact with the researchers. They go and we present our research to them. And then they say, yeah, this makes sense. Why don't you come and you present this to the other judges? How can we do to engage with this dimension of research, so on and so forth. So that is why it's so important for us to interact with the Inter-American Court of Human Rights. So, then, 4 things. General Bureau of Rights, judges are the central players, openness to international law, and international law, not in general, but to the Inter-American Court of Human Rights. And to do what? So that sounds interesting, that's different, but to do what? What are the issues? So, the point there is that why do we call this transformative constitutionalism? Why not only constitutionalism or transnational constitutionalism or international constitutionalism? The notion of transnational constitutionalism and the idea that we want to suggest, and really the cornerstone of the project, is that you can transform reality through law or by using law. Is that enough? Of course it's not enough. You need also other variables. But can you undertake certain social transformations by adjudication of public law, by using public law as a distinctive language? Yes, you can, and that's what we want to prove. That's what the whole project is all about. And what is the whole point here then? Is that our idea is that very serious social issues are not beyond the law. We react very strongly, and in that sense, our project, even though it's an academic and a rigorous project, is not politically neutral in the sense that we believe in human rights and we believe in democracy. And our argument is that even very difficult social problems are not outside the domain of the law. That very difficult situations as the ones that we saw before, social exclusion, hyper-presidentialism, extreme violence, that you can do things with law in order to change, at least in part, that reality. Can you solve social exclusion through law only? Obviously not. But can you solve social exclusion in Latin America without the law? We argue it's impossible as well. That's the whole point. And then in that sense, we react against other people who are saying, no, these kind of things are outside the law. It's only weapons, it's only force, it's only the will of the people that can decide these kind of things. And they will say, no. This has to go through a procedure, through a constitution, through courts. That's the intervention. And obviously, as you can see, we intervene in very specific debates in Latin America. That's the whole project. So that's the idea. So how? First one, inclusion. So very, very deep problems in Latin America. How do you think about inclusion? Of course, you have social inclusion and you have economic inclusion. And then we say we can use law in order to promote better inclusion. Also, what transformative constitutionalism is Latin. So think about it in these terms. So traditionally, conservative societies in Latin America have seen the rights of same-sex couples improve, for instance, because of a decision of the Inter-American Court of Human Rights. That's the case of Costa Rica. That's the case of Chile. That's also the case of Colombia. That means that people who were before excluded are now included. And that's a huge success. The second is people who were radically deprived, radically excluded from the system because of lack of resources. Think of desplazados, internally displaced population in Colombia. So did you know that before 2005, they didn't have access to Social Security? They didn't, period. And then it took a decision of the Constitutional Court. Does that, to have Social Security, does that mean that now desplazados, meaning internally displaced populations, does that mean that they are well off and that there are no problems anymore? Obviously not. We know that that's not the case. But you have to realize that what it took was litigation, a court decision, and a smart process of monitoring in order to achieve that transformation. And that's actual social transformation. Inclusion is the same thing. The other thing is voice, to give voice to the voiceless. Here is, for instance, we collaborate a lot with this civil society organization, is the Center for Justice and International Law. And this is, for instance, a hearing at the Inter-American Court of Human Rights. This is the Sarayaco community of Ecuador. And this is people going before the Inter-American Court of Human Rights saying there is going to be this exploration of oil and gas in our territory, and they should ask us. They should ask not for our consent, but at least they should have a consultation with us. Because the territory, and we all know this in Colombia, our territory is sacred, so on and so forth. This is something, so transformative constitutionalism gives voice to these kind of people who would normally be excluded. I don't have to tell this audience how indigenous populations are traditionally excluded from political decision-making in Latin America. So it takes someone who actually mobilizes this vocabulary. Once again, it's necessary, but it's not sufficient. Other things have to be done. And the third is, of course, deep structures of power. Agustin already mentioned this, so I'm not going to go too deep into how transformative constitutionalism not only includes people who are excluded, not only gives voice to the voiceless, but also really tackles and has tackled in a lot of places in Latin America some of the deepest structures of power. Agustin already mentioned the dictaduras in Argentina. So can you think of deeper power in the southern cone? And of course, we have our very own example. Our very own example. I think I ran out of censorship. So, and we have our very own, and we have our very own example of that. So those are the deep, and this was actually the last slide. Those are the deep challenges that we have. And those deep challenges, this is the last one, don't worry. So these are the deep challenges that we're trying to tackle. So how to use transformative constitutionalism in order to tackle deep structures of power, give voice to the voiceless, give inclusion in a context that basically transforms societies in a context that creates these issues that I was mentioning about. So that's more or less the idea. That's the kind of research that we're doing. And then we have specific projects on each of these different challenges that I'm very happy to tell you about in the Q&A. Thank you very much.